All right, we're going to be talking about public relations and the law. Now, this is a very involved subject, so it's perhaps going to take a bit longer for these videos and the outlines a little bit longer, but even at that, I'm skipping a lot of information. So this quite involved. Of course, we are basing our conversations here on Public Relations Strategies and Tactics, Wilcox and Cameron, the 10th edition. I hope you have a copy of that. PR personnel must be aware that they can be held legally liable if they provide advice or tacitly support an illegal activity of a client or an employer. Tacitly means wordlessly, seemingly gave your approval without saying so per se. So this would be considered conspiracy if you provide advice or support to an illegal activity of a client or an employer. PR practitioners can be named as a co-conspirator with other organizational officials if the PR practitioner, among other acts, counsels and guides the policy behind an illegal action, or if the PR practitioner helps establish a front group whereby the connection to the PR firm or its clients is kept hidden. Now, there are quite a few others here, and I'm kind of hitting the highlights of this. So the bottom line is that PR firms cannot hide behind the defense of the client told me to do it, and must practice due diligence in vetting the information and documentation supplied by a client. So you can't just presume that it's correct, accurate. So you should be in the mode of checking to see if information that you provided is good information. All right, libel and defamation. Defamation is a broader term that takes into account libel, which is something that has been published and is damaging to someone's reputation. Slander is oral; it's just the spoken word. Now, again, libel and defamation, we could spend a semester talking just about those subjects, but I'm going to play a short video for you here on this subject of defamation.
Part of the defendant. So let's look at each other.
Sorry, we're in the middle of it. We'll pick it up from the beginning.
I hope this finds you well. Today we're going to look at the common law rule for defamation and how slander and libel play into the defamation rule. The landmark Supreme Court case is New York Times versus Sullivan. We won't go too in-depth with New York versus Sullivan in this video, but I do intend to create a case brief for New York Times versus Sullivan in the near future. So let's look at the elements of defamation. There's either 4 or 6 elements when trying to prove defamation. Your regular run-of-the-mill defamation is only 4 elements, and when the defamation concerns a matter of public concern, well, then you get the 2 other layers of defamation. So here are the elements. There first must be defamatory language. It must be of and concerning the plaintiff, which is the person bringing suit. Publication of that defamatory statement by the defendant to a third person. And then there must be damage to the plaintiff's reputation. As I previously said, if the matter is of public concern, meaning something that the public would find value in, then 2 other elements must be proved, and that is falsity of the defamatory language and fault on the part of the defendant. So let's look at each element and break it down.
We'll stop it at that point, but libel is information that is damaging to someone. It is also false. It is also something that where carelessness or deliberate dissemination of this information has taken place. And this is the main thing that we are concerned with here on this. Avoiding libel suits, accurate information, and a delicate choice of words must be used in all news releases. So have to be very careful about the language used in everything we publish, but in particular news releases. Also, there's something called trade libel or product disparagement of rivals' products in presenting factuals. So if presenting factual statements, be sure that the statements are true, and then that the information is factual and scientific, that there is a basis for making the statement if you are making a statement that might be considered disparaging of someone else's product. So, but truth is certainly the best defense against libel. Statements of opinion are considered puffery and do not require factual evidence. So there is a lot more in your textbook about this. We could spend a lot more time talking about libel and defamation, but we'll leave it at that for now. There is something called the fair comment defense. Fair comment is in the realm of opinion and is permitted when the companies or individuals display their wares to the public for sale or consumption. For example, a play or a musical performance. If you put your work out in front of the public, then you have to expect fair comment. So an angry client might not be able to claim libel if something bad was said about something that they put out for the public to consume and presumably to enjoy. Invasion of privacy, and let's start out with a video here on invasion of privacy. We're mainly interested in the first and the third items here, so I'm going to move it in the middle to the third item.
So what is the tort of invasion of privacy? Well, there are subcategories of this, but basically it is a situation where you are invading on someone else's personal interest that causes them harm, so it's thereby actionable against you. Now the first one relates to marketing. It's where you use someone else's image or likeness or name or something like that to support your product. Right? Doing that without obtaining a proper release or their permission would violate their right to privacy because they have ownership interests or rights in their name or likeness. And if you use their name or likeness to support your product without them knowing, you are in effect stealing from them. So that would be an invasion of their personal privacy. One would be when you gain possession, generally through a fiduciary relationship, of private information that to disclose it would cause harm to the individual. Now, easy example of that would be, say, a medical attendant of some sort has an individual's health records and they find out some objectionable information, something that would subject the individual to some sort of ridicule or could damage their image or reputation, and then you disclose that information wrongfully to the public at large or to third parties. Now, the information is true, but it was protected. It was private information, and disclosing that to outside persons would be highly objectionable.
So we'll pause that at that point as far as an explanation of invasion of privacy. So here we are, in particular, concerned about information having to do with employees. So publications that represent employee communication, internal publications very often, company newsletters, don't enjoy the same level of First Amendment protection as regular news media. They are considered commercial tools of trade and are treated similar to advertising. We're going to talk more about this, if not in this outline, then in the next one. So you must keep employee stories, say, in a newsletter, organization-oriented, not having to do with the personal lives of employees unless you have their consent. So you wouldn't even innocently announce that a particular employee has had a baby, for example. It doesn't have to do with the organization, doesn't have to do with the company or the organization. So some tips: have employees submit personals in writing. So if they are excited about the baby being born and they submit that for the newsletter, then fine. But you would want them to submit personal information themselves. Double check all information for accuracy. Ask yourself, will this embarrass anyone or cause someone to be the butt of jokes? Don't rely on secondhand information. Don't include racial or ethnic designation of employees. So here again, we're talking very much with respect to invasion of privacy about newsletters and things of that nature. Photo releases, and this is very much in the same vein. An organization must have a signed release on file if it wants to use the photos of its employees and others in product publicity, brochures, and advertising. So you can't just take a photograph of an employee and put them in product publicity materials without their knowledge and permission. PR department should file all photos, date the photos, and provide the context of the situation so we will not misrepresent what the photo has to do with. Use of old photos may embarrass employees. Avoid using photos of persons no longer employed by the organization or employees who have died. Here's an example. The Chemical Bank of New York was successfully sued for $600,000 for using photos of its employees in ads without their permission, ads for the Chemical Bank. So the watchword there again is get permission. Here we are talking about things that you might come in contact with respect to legal issues. We're leaving a lot out here, but trying to hit on some things that as a beginning employee or mid-level employee, you might have some exposure to these situations. Media inquiries about employees do provide confirmation that the person is an employee. The title and job description of the person, the date of their becoming an employee or the date of termination, leaving in the employ of the company. And that's about it as far as what you might be able to provide if there is a newspaper, television station, news organization asking about a particular employee. So do not provide the employees, and a lot of this is common sense, their information on their salary, their home address, marital status, number of children, organizational memberships, job performance. So a synopsis there of things you can or cannot provide for employees. If someone is inquiring, a news organization is inquiring about a particular employee. Copyright law, and we're going to get into this and cover some of the basics. So here is a little bit of an overview on copyright law.
In September 2015, a judge ruled that the song Happy Birthday does not fall under a valid copyright. Although many people are unaware, for decades the song could not be used commercially without incurring royalties to Warner Chappell Music Group. They claimed that they owned the rights and collected an estimated $2 million a year off of it. But how is something so simple and universal even considered to be owned by a single company? How exactly does copyright work? Well, copyright is protection for tangible expressions of an idea. It's intended to give the creator of something original the ability to use and make money from it without others being able to use it themselves. But copyright law isn't a blanket ban. There are a number of limitations that do allow for widespread use. First and foremost, it's important to note a distinction between copyright and trademark. You might see these frequently represented by the symbols C and TM. Although they generally protect the derivatives of an idea, also called intellectual property, each applies to different types of property. Copyright tends to cover literary and artistic work, for example, movies and books. Trademark is more often used to protect a company's brand and would include things like logos and names. Trademark is the reason you don't see thousands of knockoff McDonald's restaurants, while copyright is the reason you can't just print and sell the Lord of the Rings books or download pirated movies.
So we will pause that at that point. We're also going to be talking about trademark here as we go forward. Copyright means protection of a creative work from unauthorized use. If you have created something, then you have the right to control the use of it and to make money from it. PR personnel should know, one, what organizational material should be copyrighted, and the organization itself can copyright material. And two, how to utilize the copyrighted materials of others correctly. Copyright law continued here. A PR person should keep the following in mind. This is a partial list. There are other items included, but ideas can't be copyrighted, but the expression of those ideas can be. So this may be overly simplistic, but for example, the idea of a cheeseburger. Anybody can make a cheeseburger, but you cannot imitate, you cannot make your own quarter pounder, which belongs to McDonald's. So that would be an example of the difference between an idea and then the very specific expression of that idea as a particular product. Major PR materials, brochures, annual reports, and so on should be copyrighted, if only to prevent unauthorized use by competitors. So as an organization, you want to retain the right to the use of those productions, those publications. Despite the concept of fair use, which we will be discussing in other contexts, fair use is fair use is always very brief use of someone else's material. Attribution will be provided, indicating that it comes from someone else. Also, if we're talking about particular words, then those words would be placed in quotation marks. So, despite the concept of fair use, any copyrighted material intended to advance sales and profits should not be used without permission. So, if you are trying to sell something, if you are in any way trying to profit from the use of someone else's material, then you need to get permission, even if it otherwise might fall under fair use. Quantity reprints should be ordered from the publishers. If you're going to reprint a lot of copies, then order directly from the publisher, the owner of the material. Permission is required to use segments of TV programs or movies. Permission should be obtained to use segments of popular songs. Keep that in mind, because there certainly might be a temptation there, especially with the availability of things on the internet. Photographers and freelance writers retain the rights to their works after their original use. So a photograph might appear in a newsletter, an article might appear in some kind of company publication. You do not then, the company does not have the right to repeatedly use the photograph or the article. Photos of celebrities living and dead cannot be used for promotion or publicity without permission. We'll talk more about this in the next outline. Permission is required to use the images of cartoon characters. And so take the image of Charlie Brown or Snoopy or what have you to put into your newsletter. That really is not permitted. In that case, Charles Schulz of the Charles Schulz estate would have control over that. Private letters or excerpts cannot be used in sales and publicity materials without permission. And original material posted on the internet or World Wide Web has copyright protection and should not be reposted without permission. And again, it's so easy to take things off the internet, but just because something is published on the internet rather than in a newspaper or magazine or what have you, does not mean that it's not protected. All right, we will continue this discussion in the next outline and the next video, and we'll see you then.